the Kaitlyn Conley appeal is set for tomorrow. Is this a typical appeal that will occur in front of a panel of judges? Can we talk about what's coming up?
Usually takes about 15 minutes. Everything's been filed, and tomorrow's just set for the oral arguments on it. Each side, usually has a set amount of time to make an argument, and most of the time that court, they've reviewed everything, so if they have questions, they ask you questions.
Okay.
And tomorrow's just set for the oral arguments on it. Each side, usually has a set amount of time to make an argument, and most of the time that court, they've reviewed everything, so if they have questions, they ask you questions.
Okay.
But it's everything's submitted.
Would you say it is a difficult chore to overturn a case based on the number of cases that are brought to the appellate court and the number of cases that are overturned?
Very few are overturned.
Yeah. And can you talk? I don't know how much you can say about this tomorrow. What their legal argument is.
Sure, I can tell you what their arguments are.
Yep.
They basically have 8 arguments. The first argument is that the court shouldn't have gave the lesser included offense of manslaughter in the first degree. Their second argument is that the conviction wasn't supported by the evidence presented at the trial. The third argument is that the poisoning of Adam should not have been allowed into the trial. The evidence of that. The fourth, it's prosecutorial misconduct. The fifth, ineffective assistance of counsel. The sixth is the judge was not fair. The seventh, it's the punishment's harsh and excessive. And the eighth is that the evidence at the first trial wasn't legally sufficient. 3 of those arguments are very common. The misconduct, the judge isn't fair and harsh and excessive. Those are typical arguments made in most appeals.
And insufficient defense, right?
Insufficient defense, is that typical?
If you have a new lawyer, I guess.
I wouldn't say it's typical, but it is an argument made quite often. The defense will say that the appellate defense will say that the trial attorney did something wrong. I mean, this is a little bit unique because the appellate attorney was the trial attorney in the first case. So this is kind of
right.
Yeah,
so
they differ on their strategies, and that's what the third point is about Adam. The poisoning of Adam is inadmissible. It's easy to sit here or anything, whether it's a sports game or whether it's a trial, and armchair quarterback the lack of success of somebody who tries a certain strategy. And in this case, I don't think it's a big surprise. Frank Policelli and I aren't friends, but I would be lying not to acknowledge that he's a competent attorney. I mean, Frank Policelli's been a defense attorney since I've been an attorney. Frank Policelli's tried numerous murder cases and has been successful on a few. He's a very competent attorney. His way of looking at this case and Chris Pelley's way of looking at the case obviously conflict. His way of looking at it was, let's blame the husband, and in that strategy makes a lot of sense, since the husband often is the perpetrator in a homicide of a woman, the husband or the significant other, whatever the case might be. Frank's theory, and I think obviously it was a hung jury the first time, so he watched most of that trial. I mean, I saw him at the courtroom, talking to the family during the first trial. So his theory was, no, he was, Adam was the killer, so he was going to blame Adam. And he used the fact that Adam had suffered an illness very similar to what Mary died from. And, his theory was to, point the finger at Adam, because all the colchicine was bought with Adam's identification. The email used and the name used and everything else. So, I mean, I don't think that he was ineffective by doing that. I mean, granted, he was not successful, but being not successful and an ineffective assistance of counsel are two different things. That was his strategy. I think it I mean, a reasonable person could look at that and say, okay, yeah. I mean, obviously the evidence didn't support his strategy, but that was his strategy. And, and so I don't necessarily think that, is big of a deal, but who knows? I mean, only time will tell, and the court will make the decision. I mean, he did open the door for us to get into the poisoning of Adam, which Pelley was successful in preventing us from talking about that in the first trial because of the different theory.
Yeah.
And I think that's why, in the end, between us being able to explain certain things and most importantly, in my opinion, the biggest difference between two trials was we had evidence in the second trial we didn't have in the first trial that Tony Martino had found the backup of Kaitlyn's phone on Adam's computer, which we didn't have that the first time, and that showed everything she deleted afterwards. So that was pretty significant. So, yeah.
How long will it take? Normally, these can take up to 90 days before a decision comes through. Will this be quicker? I keep hearing that we might hear a decision before the holiday.
I would be surprised on that. It's very possible, but generally speaking,
it's a big case. It seems
take about 6 weeks on the quick side, and like you say, on the slower side, 90 days. So I'm just guessing, but I would guess that we will hear something maybe in January at the earliest.
Okay, all right. Andrew, I have about 2 minutes here.
I was just going to say, you'll obviously have somebody from your staff there to argue your side at the appeal. Is that how that works?
Uniquely in 2020, we're doing it virtually, so it'll be done through a virtual appearance. So my person will appear virtually from, obviously that person will be in the office, but appearing at the court, which is in Rochester. And I suspect the defense would be doing the same.
Can people log in? Is that public?
It is public. I don't know. This is like unique, so I don't know how. I know if you go to the 4th Department, you just go to the Supreme Court 4th Department. If you Google it, generally you can watch the arguments. I'm not sure how it'll work with the virtual end of it, but yes, generally you can watch the argument.
All right.
At the appellate.
I was once involved in an appeal there, and it's. When you leave, you travel all the way out, you prepare, you're doing all this, and then it lasts for, 5 minutes. And,
it's very quick. And it's less than rewarding.
It is.
Like you drive all the way out there, and then you drive all the way back thinking, what did that mean?
Yeah.
Is that important? Is that not important? And you just wait.
Yeah.
So there's different opinions on this. I believe that the courts have, I know the courts have reviewed everything at this point. They're ready to ask certain questions. I'm of the opinion, although there's different camps on this, whether or not they've made a decision. I don't necessarily think they've made a decision, but most of them have an idea of what bothers them or what doesn't bother them. Mm-hmm. I argued an appeal against Policelli at the Court of Appeals, the highest court in the state of New York, and it was very clear within seconds that they had a position on the case, and all you could do is try to overcome that. So I would suspect, I know they've read everything, and I'm guessing that there's certain things that they might have questions of the attorneys on. So, right. Like for instance, they might say, why don't you think this is ineffective? And then you have to talk about the law and what the law specifically says about, whether or not it was a strategy. And then when we talk about the conviction not supported by the evidence, well, the law is that the evidence must be viewed in the light most favorable to the prosecution on appeal. So, then you would argue that. So a lot of times they'll ask you a question if they think they have a question on it. But it's not, you don't really get to talk too much. You just answer questions.
And if it is a strategy, that would not be grounds for, if it's a strategy and the strategy is wrong, that would not be grounds for throwing the case out, right?
Correct. Usually ineffective assistance of counsel is successful on appeal if the defense attorney did nothing, if the defense attorney didn't do what a reasonable attorney would do, like file motions, visit their client, discuss the case with their client, object to clearly evidence that shouldn't come in, things like that. And it usually has to be more than one mistake, if you want to call it that. An attorney that, doesn't object to something that they could have objected to isn't going to do it. It has to be the totality of the representation was so lacking that the person didn't get a fair trial. I don't think anybody that watched that trial would agree with that. I mean, Frank Policelli, he tried hard. I mean, he just didn't. He just wasn't successful. He didn't, bring it home, so to say, in the Kaitlyn Conley defense people world. But then again, I think there's a reason for that, and that's because she's guilty. And that happens all the time in a courtroom. The defense attorneys, try to make arguments. We've seen that, whether it was the Utica College terrorist attack, whether it was the most recent trial of the guy that killed his wife up in Rome. The defense in that case was she shot herself in the back of the head. Now, obviously that was the defense the day that she was reported missing. I mean, we didn't buy that, but that's the defense they took. That doesn't mean it's ineffective. And sometimes, in that case, what else can he argue? Yeah. In this case, I think Frank's line of reasoning was, I've got to explain why that I want to put all the culture scene in Adam's hands, and the best way to do that is to say Adam got it, Adam ordered it, Adam accidentally poisoned himself, and just go with that argument, and that was his argument, and obviously it didn't work, but I don't see where that's I don't see that strategy being such that that anybody would look at it and say, well, that was the most ridiculous argument that could be made.
I will tell you that I would expect, and I know Frank could very well be listening right now. Good morning, Frank.
Probably is.
I will say on behalf of Frank.
All the nice things I said about
That's exactly right. I'm saying
Christmas.
I'm going to hear from Frank today, and he said, I can't believe Scott McNamara.
He won't say anything nice about me, but
he actually said nice things about me today, and well, listen, you swing for the seats, and you live with the contact that you make. I'm afraid, and that's kind of the case here.
Well, on the fair trial thing, you could argue, or some could argue, that she received 2 fair trials. I mean, does that take any account into the appeal as well? That she had the first trial.
It's unique in this case because one of their arguments is that the first case there was insufficient evidence. Because basically what they're trying to do is say if the first trial if the jury should have never been hung in the first trial, then there shouldn't have been a second trial. So that's kind of a unique argument. That's not something you see very often because you don't see hung juries. You don't just see hung juries that often. Yeah. So that's an interesting argument. Like I said, a few of these arguments are very common. I mean, honestly, all of them are standard arguments that you see in different appeals. Obviously, with the exception of Adam poisoning, the poisoning of Adam not being admissible, that's unique to this case. But the rest of them are very common. Lesser included, shouldn't have been, conviction not supported by the evidence, prosecutorial misconduct, trial court wasn't fair in its rulings, ineffective, and then harsh and excessive. Those are standard arguments in different types or different cases. So.
I'll ask you one question that you might not even want to or be able to answer. Do they have anything in this appeal that worries you, or maybe it doesn't work that way?
No, they don't have anything in the case that worries me. I think she got a fair trial, and I don't agree with their arguments on any of these things. But obviously, that's a decision that the Appellate Division makes, not me. So, but I mean, we've had other cases where going into the appeal, we're like, oh, I don't know, this could be an issue, and we didn't have that. I put a team together to work on this, so I had 3 lawyers working on the appeal.
Mm-hmm. Yep.
And nothing really jumped off the page at us. where we were like, But on the other hand, you never know what the court says. I mean, I mean, there was a case that was overturned on appeal that years ago that I know we didn't really think it was a big issue, but after they argued the appeal, we knew we had a big problem just because of the questions they were asking, and the court did overturn that case. So.
Here's one other question that, again, maybe you can or can't answer. Chris Pelley being the attorney for Kaitlyn Conley here, does he have a great deal of experience in front of the appellate? Because there are two schools of thought, I believe. And that is one that, you can use your attorney to appeal. But I've always been told that it's important to have someone who is well-versed in arguing in front of the appellate court to handle the case. Your thoughts on that?
I would agree with that. I mean, if I was convicted of a crime, I'd want an attorney that was what their expertise was. Chris
Especially
is more
murder.
of a trial attorney, but Chris did hire or take on co-counsel on this. That is their expertise. So, although he's kind of got the lead name in this, and I think just because locally he's more of a known person. Appellate attorneys don't get the name recognition that trial attorneys do. So, I think Chris's name is out there, but he did take on co-counsel and that is their expertise.
Okay.
And I don't think there's an issue with her not getting a good appeal. I think they've taken quite a long time to do this. They've prepared briefs. She submitted a pro se brief. I mean, they've thrown it all out there.
Yep. All right. And your belief is that we probably won't for another 6 weeks, 4 or 5, 6 weeks, especially with the holiday coming up. Probably will be early January before a decision comes down.
With the holiday in the middle of it, I would be very surprised if we saw anything before Christmas.
Okay.
I would lean more towards the middle of January just because it's the holiday season.
Yep. Okay. Okay, District Attorney Scott McNamara, as always, we appreciate your time. Thank you so much.
Thanks for having me on.
All right. Have a great day.
Take care.
That will happen tomorrow, and we'll put a link up by tomorrow where you can just click on it. And if you wanted to, I believe the case is scheduled for the afternoon.